Leading and an award-winning solicitor situated in London. Our expertise in family and matrimonial law encompasses divorce, separation, children matters, family breakdown, and financial orders. We focus on all aspects of immigration law. Our areas of expertise extends to visas for individuals and businesses. These include spouses, students, visitors, EU applications, investors, and more. We also undertake appeals and judicial reviews of negative decisions. We hold Law Society Quality Mark in immigration law. Our family law solicitors are dedicated to finding the most effective and pain-free resolution for our clients through the provision of sensitive, effective, and affordable legal advice. We are also Ghanaian law specialists and have advised many local authorities and other solicitors on aspects of Ghanaian law. We have also advised businesses looking to relocate to Ghana. Our senior partner is dual qualified as a barrister at law in Ghana and solicitor to the Superior Court of England and Wales. Client satisfaction is our number one priority. This shows in the number of positive reviews we have received from our clients. BWF Solicitors, your preferred community lawyers.
Hello, ladies and gentlemen. You are welcome to Hanging Out with BWF Solicitors. Thank you. I believe you are having a lovely day, even though the weather is a bit funny. But hey, the program must go on. Today, as usual, I'm with BWF Solicitors, who are experts in immigration and nationality, Ghana law and practice, family law, and dispute resolution. I have with me lawyer Eunice Achampong, who will be taking us through today's topic, which is when is a valid application considered not to be an in-time application? When is a valid application considered not to be an in-time application? If you want to contribute to this program, you can do so on all our social media handles at BWF Solicitors. You can also send in your comments. If you prefer to call us live, in the studio, you can do so by calling 0744 8619711. The number again is 0744 8619711. Please share to all your contacts. I believe this program might be of benefit to someone. Let me straight away welcome lawyer Eunice Achamp. Hello, lawyer Eunice.
Hi, Vicky. How are you?
I'm good, and you?
I'm doing well by God's grace. I hope the family and everyone is doing well.
Everyone is doing well. Yes. We are all looking forward to today's program. Yes. And if you have any updates for us before, discussing what we have for today.
Okay. So in terms of our updates, I think that most people would have realized by now that in terms of our borders, a lot of people are experiencing the fact that when you are making applications to come to the UK, especially in regards to visa applications, a lot of the time, obviously, because it's a visit visa, the time for consideration is much less. They will tell you that within about 2 to 3 weeks, the application will be decided, and then you will know your fate, basically. Yeah. But of course, it's taking longer than that usual period of time to make decisions. And so they're saying that, of course, if you are now making these visa applications, you should also put into your time scales, that they're going to take
Mhm.
longer than
Yeah.
the standard period of time to obviously make decisions on these applications. So anybody who is looking to come to the UK has to put these timeframes in mind, so that when they make the application and they haven't heard from them, they just have to consider the fact that because of the volume of cases that are now being decided, unfortunately, they cannot make the decision within that standard period of
Mm.
service as they would usually do.
Okay.
And then, of course, in regards to our EA nationals as well. So, this week as well, I had someone calling me and saying to me, "Oh, they want to know if it's okay for them to come and live in the UK, and they've just gotten like their Italian passport, and they just
Mm.
want to know if it's okay for them to come and live here." And unfortunately, due to the fact that our transitional rules have now come into play. And so from the 1st of January 2021, any EU national or their family member who wants to come into the UK will definitely have to show that they are applying for a skilled worker visa, or they have applied for a student visa, or some other means by which they can come into the UK. They
Mm.
no longer have that right of free movement where they can come into another member state, because the UK is no longer part of the EU. And so, unfortunately, from the 1st of January this year, if you're an EU national and you want to come into the UK, you will have to apply for a visa to be able to come and live
No.
and stay and work in the UK. And so if you are deciding on coming, or you have already entered, because I think another issue is the fact that they have realized that a lot of EU nationals have entered the UK from the 1st of January and are now making applications under the EU settlement scheme, and they do not have proof of the fact that they were here before the 1st of January 2021. So I've had callers who will call me and say, oh, they've done the EU settlement scheme, but they have not been able to provide evidence that they were here before that date. And
Yeah.
therefore, they want to find out what they can do, basically. And unfortunately, the answer is, if you can't provide them with evidence that you were here before the 1st of January 2021, you cannot continue to remain in the UK, because of the fact that the UK is no longer part of the EU. And so,
Right.
if you're an EU national and you are in this situation, um, the only thing I can say is you're allowed a period of 6 months
Months.
visit, and that's just it. After that period, you obviously have to return to your country of origin and
Mm.
then make an application for visa if you want to come and stay and work in the UK. So those are just a few updates in regards
Mm.
to
Mm.
our immigration rules.
Right, 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 right. Lawyer Eunice, this topic, when is a valid application considered not to be
Yes,
an in-time application? Can you
yes,
move into it for us? Is it
yeah.
the way it's worded, or I mean, if you
Oh,
could
yes.
move
So
into it, yeah.
obviously, I can say that when it comes to our immigration applications, we're always looking to make sure that we are submitting it before our leave expires. So
Right.
if you have valid leave, so I'm not talking about people who do not have leave at all. This is
Yeah.
for people who have valid leave
Yeah.
to remain in the UK. So if you have valid leave and you want to make an application, the first thing on the person's mind is, I have to make this application before the leave expires.
Fine. Yeah.
I've
Right.
had situations where people have thought, oh, okay, I'm on the 5 year route. So if I'm on the 5 year route to gaining settlement, then maybe it might mean that the 2.5 years that they've given me will expire in 5 years' time. And
Yeah.
unfortunately, that's not the case. You have to obviously make the application before your leave that they have granted to you
Okay.
expires. And so that is what we call an in-time application, because
Fine.
by the time you submit it after the expiry of your leave, then you are out of time basically. So when you are making the application, you are looking to make the application before your leave expires. So
Expired.
I think that was a long-winded way of saying it, but it's simply trying to say that you should make your application before the leave expires.
Okay. All right. Ladies and gentlemen, if you've just joined us, this is Hanging Out with BWF Solicitors, um, an immigration education program. The topic is, when is a valid application considered not to be an in time application? With me is lawyer Eunice Achampong, who is a solicitor and also a partner at BWF Solicitors. She is the one going to, explain to us, what this is, and the process in which one can follow to make sure that they make a successful application. We would like to also hear from you. If you have any questions, please do send it to us, on our Facebook, YouTube page, and we'll be able to pick them up. And Lawyer Eunice will, answer that question for you. It's free legal advice, so grab that opportunity. Please share this program. We also have a landline that you can call us in the studio mobile number that you can call us, or even send us a WhatsApp message if you prefer to do that. The number is 0744 The number again is 0744 And I'm your host, Vicky Newton. Now, Lawyer Eunice, what
Hi.
is a valid immigration application?
So when we say a valid application, most people who have made applications here in the UK, whether it be for a student visa or a work permit visa or parents leave to remain visa, whatever the visa route is, you will definitely need to make a valid application. So under our immigration rules, a valid application is one where you have completed the prescribed form. So whether it's an online form
Mm,
or a paper form, you have filled in or completed and submitted that particular form
okay.
for the routes that you want to apply to. And then they also want you to have completed a valid biometric. So
Mm,
you, as an applicant, have to give your fingerprints,
right.
and they will take a photograph of your face in regards to that application that you are making. And this is part of the changes that were brought into force under our Immigration Act of 2014. So, of course, when you make an application, you know it will come with you completing a biometric. And now we have biometric cards. And so usually that is used for your biometric permit or your biometric card that most people would have had under the EU settlement scheme. So, of course, after the biometric has been taken, or
Mhm.
should I say during the time the biometric is taken, they would also want a copy of your passport. So
Right.
you should have a valid passport or identification which shows your nationality and also your identity. So they will need that form of valid identification to
Mm,
obviously identify you by. And then lastly but not least, they want to make sure that you've paid the correct fees. So if you're saying you're making an application, let's say as a parent, and you're making a further leave to remain application, you need to pay the correct application fee and
mm,
also the IHS. So you are not exempt from the IHS unless you've made a fee waiver application. So if you've made that fee waiver application and they have exempted you from paying the application fee and the IHS, then of course you can say that you don't have to pay the required fee. So that will exempt you from that. But that's in a nutshell what a valid application is. So as long as you've filled in the prescribed form, had your biometrics taken,
Yes.
have provided a valid form of identification, and whether it's relevant to you, you've paid the prescribed fee, then of course you can say that you've completed a valid application from
Application.
which the Home Office can also look at. The only reason why an application may be invalid is if you have not satisfied one of those requirements, such as not providing a biometrics, for instance. Then they can say, do you know what? Because you haven't provided a valid biometrics. And I know that last year they had emails sent out to say that, oh, we know that you have previously provided biometrics with your last leave to remain. And so you do not need to provide one now. Please
Hmm.
send us a photograph of yourself
Okay.
via email. And then after some months, I remember a client said to me, I still haven't heard from them. So it's been over 6 months. Can you find out whether they'll be making a decision on our application? Only for them to come back to say that, oh, now we want him to actually attend a biometrics center
Hmm.
and
Hmm.
have his biometrics taken.
Yeah.
So obviously, due to the coronavirus, the centers, most of the centers were closed, and so they had to find a way of making decisions for applicants who had submitted their applications during that time, and that was what they were doing. But then, of course, when the centers became open, they said, "Okay, now go back and then have your biometrics taken."
Taken.
And so, um, one of those reasons could be not providing a biometric for your application. And if that has not been done, the Home Office always have a discretion to say, okay, go have your biometrics taken or pay the sum of fees that you haven't paid. So if it's 200 that you were supposed to pay on top of your application and it wasn't paid,
Hmm.
pay that remainder. And usually they'll give you a period of 10 days to validate your application. And if
Okay.
still after that period you haven't done so, then of course you know that you have submitted an invalid application.
Mm,
Yeah.
okay. May I please remind our viewers that the phone lines are not open yet. Laura Eunice has just started, and we haven't really delved into the processes. So please bear with us. I will announce when the phone lines are open. I've seen people trying to get through, but
Oh,
please
okay.
be patient with us. Just give us just a minute for Lawyer Eunice to take us through the process. Then we'll be able to take calls for questions. Right. Laura Eunice, I think you might have touched this, but I'll still ask anyway because it was
Yeah.
a question sent before the program started. Is it possible for a person's leave to still be extended under the law if it was no, bear with me. When is an application considered as an in-time application, and when is it not? Did you get it?
Okay.
Yeah,
Yeah.
yeah.
Yeah. Okay, so in terms of an in-time application, so for instance, if they are saying to you, my leave is expiring tomorrow,
Hmm.
and because my leave is expiring tomorrow, I want to submit it as soon as possible before it expires.
Hmm.
So, of course, you know that as soon as your leave expires, then of course you basically haven't got any
So
legs
you
to
need
stand
to,
on.
yeah.
So you want to make the application
Hmm.
before your leave expires. And
Oh,
so when we say that somebody is making an in-time application, we're simply saying that that person is submitting their application before their
Or the
leave
leave
to
to
remain
expire. Okay.
expires. And then, of course, if you make your application after your leave to remain
Mm-hmm.
expires, most people will say, okay, but isn't there any leeway? Well, in terms of our immigration rules, the only leeway you have is under paragraph 39E, where, of course, you are saying that because of A, B, and C,
Mm-hmm.
I have these reasonable excuses why I could not submit it in time, and therefore I am now submitting my application.
Okay.
If you do have those reasonable grounds where you are saying that this is the reason why you are submitting it late, then they will consider it, and it might be effective for somebody to use paragraph 39E for their application,
Okay.
especially if they are going to make an application for indefinite leave to remain later on, so that it will count as a valid period where
Right.
they will not dismiss it totally as not having a valid leave, and so there was a break in their leave. And you
Mm.
don't want that when you are applying for indefinite leave to remain. So
Okay.
that also helps in that sense. But in the nutshell, making an application before your leave expires is what we term as an in-time application.
Application. Okay. Um, Let me take this call. Check. Hello, caller. Hello. Hello, caller. Okay, hold on. You want to ask a question? Okay. All right. Where are you calling from, Anthony?
I'm calling from Middlesbrough.
All right. Can you please tell your Eunice your question? Ask your question, please. Your question.
Okay. I'm a student from Ghana, and now I have a child with a British lady.
Okay.
So I learned there's a way I could switch from my current status to FM or so. So I've discussed with this lady, and she has given me all the details I need, documents I do. So I'm just thinking if I can go straight away and do the application online, or I need a solicitor to do that on my behalf.
Okay. All right. Laura Eunice, did you get the question?
Yes, so he says that he's had a child with somebody who is British. Is he living with this person, or they are living separately?
Are you living with this person?
No.
He's not living with her.
No.
Okay.
Relationship anymore.
You are not in a relationship anymore.
Okay,
Okay.
that's
All right.
fine. So he's making the application as a parent to this child, and I hope he's playing some role in the child's life. So of course, if he wants to make that switch, I hope he has a valid student leave. If he's making the switch whilst his student leave is still valid, then he can make the application on the 5-year route. And he definitely obviously needs to meet all of the requirements in order to make that application. So I mean, it's an online application. If he feels that he's suitable enough to make the application on his own, he can go ahead and complete the online application. It's FLRFP. So he can complete the application on his own if he so desires. But of course, he should also have in mind that he has to meet all of the requirements to be able to make a valid application and then switch from the student route to the parent route.
Okay, so that means this application is straightforward. It's not that complicated.
Yes, as long as he can meet the immigration rule requirements. So most people can complete the online application, but they may not know what the immigration rule requirements are in terms of making such an application. So
All
Yeah.
right. Okay. Laura Eunice, is it possible for a person's leave to still be extended under the law if it was not submitted in time?
So, like I just mentioned with the other example that we were given, if, for instance, somebody said to you, "Oh, I couldn't submit the application early enough because I wasn't able to get enough of the documents. So I needed documents A, B, and C, and I wasn't able to get it. So I didn't submit it in time. Can I still go ahead and submit?" Yes, of course. If, for instance, you have now gotten your English language certificate and
Mm,
you are thinking about making the application, yes, you can, but you have to also realize that you only have a time frame of 14 days under paragraph 39E. So if your application is not submitted within 14 days of your leave expiring,
mm,
then it means that there will be a break in your status when you
okay.
apply for indefinite leave to remain.
Mm,
So you have to realize that within that 14 days, you have to submit the application as soon as possible to be
mm,
able to be covered by paragraph 39E. Because, of course, if you are thinking about making an application for indefinite leave to remain, then you should be able to have that continuous residence in
mm,
order for that leave to be counted towards your leave to
leave
remain.
to remain.
So
Yeah.
it's important that, of course, you bear in mind that within that 14-day period, you are supposed to submit that application. Of course, during last year's pandemic, a
Mm,
lot of people did not make their applications in time because they were out of the country
mm,
and there were restrictions and there were other things that got into the way of them making their
yeah.
applications in time. So we have concessions and now we have it in the guidance where if you were restricted from coming into the country and your leave expired whilst you were out of the country, you can now make the application, or you would have been able to make the application, and it will not be counted against you if you were prevented from coming into the country from March of last year to August of last year. So they will not count that period against a person who could not come into the UK for those purposes. And so, Corona is a very significant thing that happened
Mm,
um, in the world. And so, there's a concession, or there is under the Home Office policy or guidance, this clause where it says that if for that reason you could not make the application,
yeah.
of course, not making the application in time because of coronavirus, we have protection available to you. So you can rely on the protection that we have given to you, and you'll be fine when it comes to making your application for indefinite leave to remain. And I think it applies to almost anybody who is making an application under
Hold
any.
on. Mhm.
Yes, so those concessions are around the board. So, of
Okay.
course, if you're a student, if you're a skilled worker, if you're somebody who's applying for further leave to remain,
Mm,
those concessions are available to you if you could
okay.
not make the application in time.
All right. Right. We've got another caller on the line. Hello, caller. What's your name and where are you calling from? Hello. Okay. Right. Right.
Yes,
Ladies and gentlemen. Yeah. So have you finished with
yes,
this
yes. I had
topic?
finished with
Well,
that
the certificate.
particular
Yeah.
question.
So, if you've just joined us, this is Mangina with BWF Solicitors. This is a free legal advice, show. Today's topic is when is a valid application? I have to take my time. When is a valid application considered not to be an in-time application? And with me is lawyer Eunice Champong, a solicitor and also a partner at BWF Solicitors. And let me take this caller. Hello. Good morning. Where are you calling from? What's your name?
My name is Nora, please. I'm calling from Birmingham.
Okay.
I would like to ask a question, if you don't mind, please.
That's fine. Eunice is here.
Thank you. Eunice, good afternoon.
Good afternoon.
My question is, I have done a fee waiver application, but it's been 6 weeks now, exactly 6 weeks on the 26th, but I've not heard anything from them, and not come back to even request for if they would need any more documents or anything. And my leave to remain will expire in 2 weeks. So I wanted to find out if should I keep waiting to hear from them, or I need to get in touch with them. And if I have to get in touch with them, what contact details can I get them on, please?
Okay, so in terms of the fee waiver applications, there is a protection in regards to our immigration rules. So usually when you submit a fee waiver application, they give you a period of 10 days to submit the application. And then, of course, you know that your application is being submitted in time. And in her case, she's saying that her leave to remain is expiring in 2 weeks' time, and she still hasn't heard from them. Usually, they have an email that they will ask you to upload documents to. And so usually you can, okay, so usually you can also email them. I know on the checklist, sometimes they will put an address where you can forward documents to as well. So you can look on the checklist for further details if the need is urgent. And so, of course, if you have a copy of the checklist and you want to make contact with them, you can do so. But at least you know that if the fee waiver decision comes. So usually with fee waiver decisions, either that they are requesting for more documents to be submitted, or they will be asking that, of course, you make explanations clear to them as in regards to your bank statements and the rest of it. But once you have a decision, if your leave has gone past the date that you were supposed to make the application, you have that 10 days, because the fee waiver application in itself is a valid application. And so you make that application because you are making a request to the Home Office for further leave to remain. And that fee waiver application is part of the whole process. So if your leave is beyond the 2 weeks that you are talking about and you still haven't received a decision, you still have that 10-day period to submit a valid application to the Home Office within that time. But you can contact them as well during this time, just so that you know that they are still considering it, and they will get back to you as soon as possible.
Well, what is the time frame?
Thank you very much.
What is the time frame for this application?
In this sense, is a 6 weeks waiting period long time to get in touch with them, or I should wait till I hear from them?
Usually with fee waiver applications, I think it depends on the caseworker. Some caseworkers will get back to you within a period of 4 weeks. Some caseworkers will get back to you within a period of 8 weeks. I think the longest will be 3 months. So it depends, I think, on the caseworker dealing with the application. Fee waiver applications don't necessarily have a standard period of service, so you can still contact them to find out if they need any further documents, for instance, or anything like that.
All right.
Okay. All right. Thank you, caller. You're welcome.
Bless you for the great job you are doing.
Thank you.
Thank you.
Bye. Have a lovely day. Bye-bye.
You too. Thanks. Bye.
Yes, so there you are. No, it is. With this application that this lady is talking about,
Yes.
I just want to find out from you. You have to pay before your application is acknowledged.
Yes, submitted.
Right?
Yes.
So if you are still applying for a fee waiver, how do you put, because she's got only 2 weeks,
Yes.
how are you able to put in a valid application whereby you know that you submitted the application in time, or else
Yes.
if you, because you're waiting for the fee waiver,
Decision.
this
Yeah.
to come out, then you'll be waiting and your leave will be, will expire. But
Yeah.
then when I started to pay, isn't it? Or in your application, you have to state that you are still waiting for the fee waiver decision. Will the application still be accepted?
So usually, if you have the money to
Mm,
make the application, then
mm.
of course you wouldn't need a fee waiver because
Exactly.
then you
Exactly.
can make the application in
So how
time.
do you ask for a fee waiver? Then when it comes to the last minute, like you've got few days for the, your leave to
That's why I
then
explained
you
to
get
her.
control magic. You are able to get, but it could be that you
Yeah,
borrowed from relatives and family. Do you get what I'm saying?
of course.
Probably they
Of
wouldn't
course.
see it that way. So if you have this avenue, why are you asking us for fee waiver?
That's another thing. So of course, if you don't have the funds and you're relying on this fee waiver decision to
Mm,
make the application, then of course you should make sure that you are 100% sure that you cannot afford the fees whatsoever. Because the only time they would refuse a fee waiver or they would tell you to pay part is if they can see from your bank statements that, well, you have the funds available, or
mm,
they can see that maybe you can pay for the application fee, but maybe you can't pay for the IHS. So we will allow you to pay for the IHS, and then we'll give you a fee waiver for the application fee itself. Or we can see that you can pay for the application fee, but you can't pay for the IHS. So we'll allow you to pay for the application, and then we'll pay for the IHS. So it has to do with the affordability. And so if, of course, you know you can pay for the application, then you might as well go ahead and then pay for it. But the fee waiver application, whenever you're doing a further leave to remain application,
mm.
it takes you on to that page where you can apply for fee waiver even before
Okay.
you
Okay.
make the application for further leave to remain.
Right.
So it is within the further leave to remain application, if I can put it that way. So you applying for a free waiver is like making a valid application for further leave to remain. And so, of course, if they bring a positive decision that you can pay, I mean, they would pay for your your fees for the application, or
Mhm.
they will partly pay for your fees for the application. Then you know that you have 10 days to make the application. And then, of course, if it's a fee waiver, then you don't have to pay the
Right.
prescribed fee
Okay.
because
Okay.
they have waived it off. And so that requirement will not be applicable to you, and it will still mean that you've made a valid application because they have decided to waive the fee on your behalf. So,
Okay.
yes, that person can still go ahead and make that application in time.
Oh, okay. All right. Lara sent in a question, said, I've submitted an application for further leave to remain as a parent of a British child. Unfortunately, I did not have the funds to pay for the application before
Mm.
my leave expired. So it was submitted late. Will
Mm.
that affect my work? Can Lara give a tangible reason why her application was submitted late, and will it be accepted?
So, if Lara can explain
Mm,
why the application was submitted late, and she needs to obviously have a valid reason. If she was able to do it within the 14 days that I was talking about under paragraph 39E of the immigration rules, then of course she can rely on that and say that maybe she was struggling to make the money ready.
mm.
People like that maybe is because they know that they earn enough to be able to pay the fees and they will
Okay.
not be granted fee waiver. And
Yeah.
so because they know they earn quite a lot, they
Mm,
would rather pay for it than to go and apply for a fee waiver because they know that the funds in their account will show. So if that is the case and she's saying that this is the reason why she was not able to submit in time, then of course she can use that as an excuse and say that this is the reason why. And of course, when it comes to the fact that her work people would demand something, yes, when it comes to making a valid application for the purposes of our home office, they obviously consider that somebody who has made a valid application is protected under paragraph, sorry, under section 3C of our Immigration Act of 1971. So
Okay.
if you make your application and your leave is still valid, then you know that by law you are protected under section 3C, because section 3C talks about somebody making an application, and then whilst their leave is still extant, they are hoping, or they have an application pending where they are awaiting a decision. So if in that case you are saying, I've made my application whilst my leave is still valid or is still extant, I'm waiting for a decision, and therefore, until a decision has been made, then I am still protected. It's as if my leave never expired. The same rights that I had when my leave was valid, I still have it. So if I can work, and if I can basically have an account, if I can rent and do all those things with my valid leave, when my leave expires and the application has been submitted to the Home Office, my leave is still continuing because they haven't come back with a decision.
Yeah.
But where your leave has expired and you are not making a valid application, so you are not making the application whilst your leave is still valid, then you are not protected under Section 3C of the Immigration Act. And so when it comes to your employers, that would mean then again that because you have not provided evidence that your application was submitted before your leave expired, therefore, under the law, you have made an application which was out of time.
Fine.
And
Yes.
it means that you are not protected. So your employers will not be able to verify, because the Home Office will always bring back, should I say, invalid receipts when it comes to the validity and the confirmation of whether you can work or not. And it's an online process. So most
Right.
employers will just put in your details, and then they will say to you that they've sent a request to the Home Office. They are waiting for the request to come back. And if it comes back positive, then you can continue working. But if it comes back negative, then it means that unfortunately you don't have the protection afforded under Section 3C, and therefore they will tell you you can't continue to work. They will either suspend you or tell you that until your valid leave has come, you cannot work. And so that is the danger of obviously not applying for leave whilst your leave is still valid. If it expires, then it means that you are no longer protected. And if you're no longer protected, then it will affect your right to work. Because then, of course, you can't have that protection which is afforded to you under Section 3C of our Immigration Act
Immigration Act.
1971.
Yeah.
Yeah.
Yep. Yes, Nana says hello, Eunice and Vicky. I love your program. Keep it up. Says good afternoon. I am making an application for leave to remain on the 5-year route and currently waiting for my university transcript to be assessed whether I satisfy the English language requirement. My current leave will expire on 1st December 2021. Can I submit the application before I receive your response, or will paragraph 39E protect me?
So this is somebody who is making an application, and obviously he hasn't got much time, and he's waiting for a response. And one thing about the whole application process is that they will ask you these questions. Do you satisfy the English language requirement, or do you meet the financial requirement, or do you have suitable accommodation? So within the online application, it will ask you all these questions. And if you are not able to satisfy one of the requirements per se, then of course, if it's a family life application, so you're making the parent roots application, or you're making the application as a partner. In his case, he says he's making it under the 5-year route. If you don't meet one of the requirements, then they would say to you, does EX1 apply? So if EX1 applies, whether you have a child and therefore it will be unreasonable for this child to leave the UK, or you are saying that you have a partner and it will be there will be insurmountable obstacles, so very great difficulties or harsh difficulties if you and your partner were to return to your country of origin, then of course they can put you on the 10-year route.
Okay.
But in terms of being on the 5-year route, you have to be able to meet the requirements. So for him to say that he is waiting and he hasn't got an idea as to when they would get back to him, if he wants to contact them to find out if everything is good to go, then I think it will be best for him to contact them. Otherwise, he should just go and do the ISO and put on there
Yeah.
that he will be providing an ISO
Yeah.
certificate. So in that case, when you're making the application with ISO, if you've done a university degree, you can do it. Because even people who haven't gone to school can do the ISO.
Yeah.
So you might as well just say that you provide an ISO certificate, and that's to the application stating that you satisfy the requirement because you are going to do that English language test. And obviously that will help you meet the requirement for the English language rather than waiting for ECTIS to get back to you about your degree. Just go and have the ISO done, and then of course on the day that you do it, they give you your pass, whether you've passed or not passed. And so you can just put that you have passed immediately and then submit the application in time rather than waiting for ECTIS to get back to you and you know that your leave is expiring. So yes, I would rather he do the ISO and then meet
Oh,
the English language requirement. Yeah.
no, Eunice, this is a question that I wanted to ask you. If I am waiting for a document and the deadline for my my stay
Mm,
is in a couple of days, can I
mm,
deliberately put in the application and
mm,
also write a statement that this is not all the documents, but I'm still awaiting, like what this gentleman is saying,
mm.
his transcript. With
Yes.
that, will the Home Office accept it, or would they make their decision on whatever documents that you've submitted at that time with the application?
Okay, so when it comes to, for instance, let's say family life applications or
Yeah.
human rights applications, the Home Office always have that discretion when it comes to producing evidence or producing documents. So usually, once you have submitted the online application, it is deemed that you have made the application in time before your leave expires.
Yes.
Sometimes you are not even able to do the biometrics
Mm-hmm.
before the leave actually expires.
Yes.
As long as you have submitted the online application during the time your leave was still valid, or during the time your leave was still extant, then you know that you are protected because that has your payment done, and you've also made the prescribed application. If so, so if you have done that and you have booked for a biometric and you have produced your fingerprints and your identity to them, usually at that time they will ask for copies of your documents to be uploaded.
Yes.
So at the time of your biometrics, you know that you are also going to submit your documents,
Yeah.
or either that they have provided an address for your documents to be posted to, and therefore your documents will be posted to that address. It is at that time that they consider all of your evidence that you have brought for the application. So, of course, if you are making the application and your leave is going to expire in 2 days' time,
Mhm.
please make the online application. It is not at that particular time that they will be taking the evidence. They would usually, in some cases, give you an email address for you to upload the documents to them,
Yeah.
or they will ask you to go to the center and have your documents scanned, or you can upload the documents yourself and then have it taken off by UK VCAS. So UK VCAS are the people that do the biometrics and the rest of it. So
Oh,
at the time that you are making the application, if you haven't got the document at hand, like I was explaining in this gentleman's case, if you haven't got the document, you know that you're going to sign a declaration at the end of the application saying that you believe all that has been stated in this application to be true. So if you haven't got the results and Access is probably tossing you up and down, bring that, bring this, we can't verify it until we have A, B, and C, then I would say you're better off just doing the ISOL that you can do in 1 day and just get it out of the way. Once you've done it, you know that you're secure. And so you can tick on your online application, I've done the English language test and I've passed. Even though you don't have the certificate in front of your face, but at least you can provide that to them. And even during the corona pandemic and the restrictions in place,
yeah.
they gave people the opportunity to say that um, there is an exception because the centers were closed and they were finding it hard to book, and therefore they will provide the English language requirement at a later time because they couldn't do it at the particular time that they made the application. So all these concessions were available at the time that obviously the pandemic was really high. And so, yes, when it comes to providing the evidence, you may not have the certificate right in front of you, but as long as you know you've passed, you can just submit it and say that you have passed, and the certificate will be provided to them once you've received it.
Okay. All right. Ophelia says this question is not related to today's topic, but is it possible to pay for priority service of £500 instead of £800 as stated on the government website?
If you're making the application in country, I know that for applications such as our family life applications, the
Mhm.
only fee that you can pay is the um, £800 super priority service.
Okay.
There might be obviously the skilled worker routes and the student routes where the application for priority service within a few days will be applicable. So you will be able to pay the 500. And I know that those outside of the UK who also want priority service for, let's say, spousal applications or making applications for their children to join them, will also have to pay, I think, 530 something pounds for the priority service. So for further leave to remain applications specifically, it is only the £800. You can't pay less than that.
Oh,
And then I think for other applications, you have that option to pay the £500 priority service fee.
okay. All right. Ladies and gentlemen, if you've just joined us, this is Hanging Out with BWF Solicitors, your number one immigration law firm in the UK. Today we are discussing, or we've been discussing, when is a valid application considered not to be an in-time application? And with me has been lawyer Eunice Achampong, who is a seasoned lawyer, one of the best female lawyers, and also a partner at BWF Solicitors, who has taken time off a busy schedule to be with us and take us through the process, procedures, and also answer a few questions that viewers have been sending us, regarding this topic. If you have any questions or you have any comments, please do so on all our social media handles at BWF Solicitors, Facebook, YouTube. We would like to hear from you. Or if you prefer to call us, in the studio, you can do so on 0744 As usual, I am your host, Dickon Newton. Lawyer Eunice,
Hi.
I think I've exhausted most of my, questions
Question.
from
Yes.
our viewers. Have you got any from your end, if I may
I was
ask?
just checking. Not
Yes.
really. So we can
Okay.
move
All right.
on.
Okay. So, Laura Eunice, quickly, if you would please summarize what we've talked about so far, then if people watching would like to get your contact details for them to, come to your office, because I believe sometimes sending in their questions or calling live on the program to talk about their issues, they may need to physically see you for further advice, because
Mm,
each situation is different. We cannot generalize it. So if you can do so, we very much appreciate it, so that they can get in touch with you for further support and guidance.
okay. So as the topic relates, it is to do with making an application before your leave expires. And so if you are making your application, you want the utmost protection when it comes to you, especially having that right to continue to work.
Yeah.
If
Yeah.
you are making the application before your leave expires, you know that you will definitely be protected under Section 3C of our Immigration Act of 1971. And
Mhm.
if you do not make the application in time or before your leave expires, then you would not be protected under the law. And so, if for any reason you are thinking, I should be able to provide my employers with my right to work,
Yep.
you give them the application number or you give them the home office reference number, and they do their employability check and they are not able to verify that you can work, unfortunately, because the law does not also protect you, then it means that you will have to wait for the home office to make a decision on your application before you can continue to also
Okay.
work. And so it's important that where the need is urgent for you to make the application, you go ahead and make the application before your leave expires. Obviously, to somebody who hasn't made an application before or hasn't got any work restrictions because they don't work, this will not be applicable to them. So it wouldn't matter as much. But where you know that your employers will be chasing you or they will be asking for some form of redress in terms of whether you're allowed to work whilst your
Mm,
application is
mm,
pending,
mm.
then you should be able to make that application in time. And of course, if anybody has any further questions, not just in regards to today's topic,
Yeah.
any other issues, whether it be family, your children,
Mhm.
any form of dispute resolution, then please do contact us. I will give our details out. And of course, you can contact us at BWF Solicitors. Our address is the fourth floor of Anna House, 214 to 218 Tottenham High Road, London. Our postcode is N15 4NP. So N15 4NP. Our office telephone number is 0208
Mhm.
493 73 40. So 0208 493 7340. And our email address, usually some people like to email, so our email address is admin@bwfsolicitors.com. So admin@bwfsolicitors.com. And my personal number out of office hours is 075 35 81 3910. So 075 35 81 3910.
Okay, well, Eunice, this is a follow-up question regarding the priority service. If you
Okay.
don't mind. Yes,
Yeah.
it's from Iram Awomeza. She
Okay.
says, good afternoon, Lawyer Eunice. Please, the 800 for priority service, is it for each person or family? Because we are 5 in family due for renewal.
So the £800 priority service is for each person. So if you want a 1-day service and you don't want to wait 6 months or over 6 months for your application to be decided, then it's £800 for each person.
Okay.
I know it's a lot of money. It's very high. It's on the high end, but that's what they charge for that priority service, and so it's for each person.
Okay. All right. Thank you. I hope Aram you've got what Lawyer Eunice has given, the answer she's given to your question. Yes, Lawyer Eunice, are you done?
Yes, please.
Okay. All right. So let me quickly give a shout out to about 3 or 4 people because of time, just to acknowledge them. Like I always say, please do forgive me if I'm not able to include your name because of time. I'd like to give a shout out to one of our top fans, Lady Louisa Asante Amwa. Hello, Lady Louisa. Always tuning in every week. Sandra Frazier as well. Hi, thank you so much. Robert Asare, he says, this is amazing. Thank you guys for helping our community. Yes, so just a shout out, and a shout out to all of you watching us all over the world. The calls are so many. Yeah.
Yes.
So we encourage you to keep contacting us. Lawyer Eunice has let her details. Please get in touch with her, and she'll be very happy to help you with any assistance you need with your documentation. Right. So on that note, we would like to say thank you so much for staying with us through the program. Definitely we will see you another time. Lawyer Eunice,
Hi.
what are you up to after this program, if I should ask? I've put you on
Oh gosh, my kids are just behind the door. They're just waiting.
They're waiting for the program. All right, so I'll make it quick and snappy. Ladies and gentlemen, thank you so much. Thank you so much, and thank you to the BWF, solicitors team. We very much appreciate your dedication, sacrifice. So until we see you, another time next week with another interesting topic, take good care of yourself. Stay blessed. We love you all. Bye-bye.
Based in London, we are a dynamic award-winning firm specializing in a range of legal services, including family law, matrimonial law, immigration, dispute resolution, Ghanaian customary and family law. At BWF, our solicitors are pleased to offer high-quality legal representation at competitive rates. Our senior partner, Bernardo Wusu, has over 29 years' experience as a lawyer in the UK. BWF solicitors provide independent and practical legal assistance for all kinds of family matters, such as childcare, contested and uncontested divorce, and injunctions for domestic violence. Our childcare and family team appreciate the issues facing you in this difficult time, which is why we offer confidential advice delivered in a sensitive manner. Our senior partner is an accredited member of the Law Society Family Law Accreditation Panel which guarantees expert representation in all family and matrimonial cases. Are you seeking advice on immigration-related matters? At BWF Solicitors, our immigration team are experts in dealing with everything from general immigration to complex immigration work permits, arranging student visas, as well as entry clearance visas, family visas, and appeals. Our senior partner is an accredited member of the Law Society Immigration Accreditation Panel, which guarantees expert representation. Our office is open from 9:30 a.m. to 6 p.m. Monday to Friday, and on Saturdays by appointment only from 10 a.m. to 4 p.m. We are located at 4th floor Anna House, 214 to 218 Tottenham High Road, London, N15 4NP, just a short walk from Seven Sisters Underground. Our senior partner, Bernardo Wusu, is also a qualified barrister and a member of the Ghana Bar Association. He has acted as an expert in court cases involving aspects of Ghanaian law. He has also advised local authorities, the official solicitor's office, and other solicitors on the intricacies of Ghanaian law, and is a regular contributor on the radio and TV on matters concerning Ghanaian law.